Hey guys, Brent Boyer here from Adam. So let's talk divorce. I want to talk today about mandatory versus permissive agreements in a divorce judgment. So when you're getting to the final stages of your divorce, you're reaching an agreement on things. I want to talk about categories that are required and categories that are not required, things that you could do if you want to agree to, and things that you must do and must agree to. So a couple examples. There are a few things here when you're reaching a settlement agreement in your divorce. For example, if you have children, if you have minor children, there might be a discussion about extracurricular activities like soccer, travel hockey, volleyball, whatever the expenses might be for a child. Things that are really not in the category of child support, not a typical food and clothing and housing type of issue. So you get into a discussion about, okay, my child's gonna play travel hockey, that's gonna cost $1,500 a year, who's gonna pay for that? Now you can agree to just pay for all of it, or you might agree to pay based on a pro rata division of incomes, meaning you make 70% of the household income right now before you're divorced, so you agree to pay 70% of the extracurricular activities, 70% of the travel hockey. One caution I would have on that is you do not want to put that in a divorce judgment, because once you make an agreement and put it in your divorce judgment, it becomes mandatory, meaning I could end up put in jail for not paying my part of travel hockey. Well, that wouldn't really make any sense. So we want to avoid that. So you can make agreements as you're going along and discussing property settlement and how everything's going to go in your divorce. You can agree on who's going to pay their share of the extracurricular activities, hockey, whatever it might be. But you do not want to put that in your judgment. So one category that works like that is extracurricular activities for minor children. Another category that works that way, that comes up in divorce settlements, is college expenses. So same idea here. You could agree to pay part of the kid's college expenses. You might agree to be saving for it, whatever age they're at, you're looking forward to that and planning on helping them and paying your share. But what you do not want to do is go one step further and include that in your divorce judgment. Because if you make an agreement, you're now stuck with whatever happens. So again, you could agree to pay 50% of college expenses for your child, and then 5 years later, you're unemployed, can't pay it, and now you're in court fighting about it. You could be, there could be enforcement provisions against you. The extreme example being you could be put in jail for not paying your share of your child's college expenses. You also want to avoid the whole deadbeat sort of approach to life that, well, he's ordered to pay part of college or he's ordered to pay part of travel hockey, that's why he does it. What you want is to keep voluntary payments, voluntary expenses for children voluntary. Don't turn them into involuntary, turn them into mandatory, and make them part of your divorce judgment or part of a court order. So the two categories to avoid there are extracurricular expenses and college expenses. Those are two things to stay away from. Make agreements on them, make side agreements, have discussion, make promises, but keep them out of court orders. I hope that helps. Don't forget to hit subscribe and like on the video, and if you have any questions, phone number and email are at the end of the video.